thank all of you. Really grateful for all your observations and insights. So we're going to have audience Q&A. Someone in the back has the microphone. But just to kind of get the ball rolling, I guess I'll pose a couple of my own. So maybe, Kendra, you could just tell us a little bit about the other plaintiff moms and what they think of having this case head to the Supreme Court.
So I don't know if I can entirely speak for them, but one of the other moms, Jerry Anderson, is a single mom. She has a little girl from China that she has raised up. She's actually in the same class as Sarah, and incredibly intelligent girl. And she was far too advanced for public school system. And so her mom has her at Stillwater Christian School because the academic, they have such a standard for academic excellence there that she does very, very well there. And so she has some support from her family as well too, but she is a single mom as well. The other one is Jamie Schaefer, and her and her husband have 2 children, and they both work, but like so many of us, it's hard to afford the tuition at a private school. It's very, very costly. So they have relied on scholarships and financial assistance through the school and through programs such as this, as have I and Jerry.
Great. And then one for Erica, too. So states like Massachusetts and Michigan have what many consider the worst Blaine amendments. If the Supreme Court rules the way school choice advocates hope that they will, what are the prospects of the amendments in Massachusetts and Michigan being either undermined or damaged in ways that make vouchers or education tax credits possible?
I think the chances are very good. We're going to win this case, and it's going to undermine these Blaine amendments nationwide. And I think with the work of the Pioneer Institute, you'll be able to make really good progress getting a program here.
Great, thanks. So again, there's a microphone. I just asked that you ask a question, no statements, and there's, one of the great things about this topic is that it's a wide-ranging topic. Is that at the beginning there's legal dimensions, historical, educational, et cetera, and just make sure that it's focused on this topic and this topic only. And please make it a question, not a statement. So there's a mic. Yep. How about Peter Scary there? Yep.
Hi, my name is Peter Scary. I teach political science at Boston College. I guess my question is directed either to Erica or to Jamie or whoever else wants to take a whack at it. But could you address some of the differences between voucher programs and these scholarship tuition programs, and what the legal theoretical implications of that is in terms of this current case?
That's a great question. So there's 3 types of school choice programs out there. There's the most traditional type, which is voucher programs. That's just government giving money to parents that they can use as scholarships. Then there's tax credit programs, which is what we have in Montana, and that works a little differently. The government is giving a tax credit for people who provide private donations to private nonprofit scholarship organizations. And those organizations then use that money and give it to parents. There's also a third type. It's called ESA programs. They're actually the next step in school choice. The way they work is the government gives money in a bank account to parents, an educational savings account. And those parents can use that money for any educational expense, whether it's private school tuition, tutoring, online learning, homeschooling. And it really allows parents to customize an education for their child. Now, your question was, well, if Espinoza involves a tax credit program, how is this going to affect other programs like vouchers and ESAs? I think it is extremely likely that the court will issue an opinion that says across the board, you cannot exclude religious options from any of these programs. Even though Montana's program is a tax credit, I think it would be very difficult for them to have a principle that would say, you're violating free exercise in this case, but you wouldn't be violating free exercise in the other case. So I think this is going to help school choice across the board.
So it would be unreasonable to think that scholarship tuition credit programs are safer from challenge than voucher programs? I mean, they were set up for a reason, weren't they? I mean,
Well, the reason that, there's a lot of reasons that states decide to do a tax credit program instead of a voucher program. Some are political and some are legal, because they will look at the Blaine Amendment in their specific state and say, well, the wording here seems like it would allow a tax credit but not a voucher. But in the Espinoza case, what's probably going to happen is the court is going to say, you can never use Blaine amendments to exclude religious options in these programs, regardless of what kind of program it is, because that violates religious liberty.
thank you.
Great. Maybe Eileen?
This is kind of a little bit of a violation, but Naomi and Sarah, we were all once your age, and I suspect most of us wouldn't be able to do what you're doing. So this is really a comment in admiration of what you're doing and coming with your mom and going through this whole thing. It's not typical. And the question is, do you have anything you want to tell us since you've been going through this? You don't have to. I don't want you to feel on the spot. But as you know, as you listen to all this, is there anything you want to say? Listen, I'm with you. That's what I would have probably done. But thank you. I think you're very cool kids.
Jack?
Hi, this is a question for Erica. Which of the multiple arguments in the brief by the Department of Revenue of the state of Montana concerns you the most, and what is your rebuttal to it?
That's a great question. I'm actually working on the reply brief right now for the case. The department filed their brief last Friday. And the biggest argument they make, I don't think it's the best argument, but this is the one they think is the best, is that the fact that the Montana Supreme Court invalidated the entire program for both kids at religious and non-religious schools means there's no longer religious discrimination. The problem with that argument is that the only reason the court invalidated the program was because it included religious schools, which is discriminatory. So they think that's their best argument, but they're going to lose.
This fellow right here.
So what would be the recourse if you win, since the program is cancelled?
So the remedy in this case, we're not asking for any money. We're just asking that the scholarship program be reinstated for everybody. And that would be the recourse here.
This fellow in the back.
Thank you.
I'm not that familiar with the case, but my understanding was, at least part of it, was whether Department of Revenue's interpretation of a tax credit as an expenditure of state funds fell under that provision. Is that at all relevant to your case?
So it was relevant for a long time, but it's no longer relevant. So in the Montana state courts, we argued that the Blaine Amendment didn't apply to the program at all because tax credits are not public dollars, and the Blaine Amendment just applies to public dollars. And in fact, courts across the country have come out that way and made that same conclusion. The Montana Supreme Court disagreed, but because they have the final authority on interpreting their own constitution, that issue is no longer on the table. And for the purposes of this case, I think the U.S. Supreme Court will just assume that tax credits are the equivalent of public money, or at least I don't think it will be a big part in the case.
Great. Dave?
Hi, I'm David Anderson. I'm an old voucher warrior, and one of the arguments we used to make concerned the United Nations Declaration of Human Rights, which I believe is a treaty that the United States ratified that says in Article 26 that parents have the right to direct the education of their children. I'm wondering if that could be used in your case.
Well, there is a U.S. Supreme Court case titled Pierce Sisters that says the same thing, that parents have the right to direct the education of their children. But that doesn't answer the question of, well, what if you're talking about government benefits and not your own money? Certainly, nobody in this country would say that if you're using your own money, you can't use it at religious school, but it's a different question when you're talking about a government benefit.
So I'm going to exercise my the moderator's prerogative here. I got a question for Mike. So those who support the status quo and oppose private school choice are likely to be politically active in states and nationally, specifically in a presidential election year. What are sort of some of the political consequences of this case, in your opinion, Mike?
Well, I think that, like most things in our society, it's polarization.
Use the microphone,
And
please.
I think that as 20 years ago, when I was involved in this case in Massachusetts to put in place a referendum to repeal the Proto-Blaine Amendment in this state, the teachers' unions came out strongly against it. And I would expect that nationally, that the teachers' unions, assuming we're successful at the U.S. Supreme Court level, the teachers' unions will mobilize nationally every dollar they've got to fight this and to prevent a loss of students I think that if this is successful, not only Catholic schools will do well, but there'll be a whole series of other schools that will emerge that are not publicly controlled, and they may be, who knows what they might be. You can just guess what they might be, but people will want to have control of the education of their children, and they will seek liberty, they will seek control over their own schools, free from the public schools. And also I think that we've seen nationally that minority parents believe this is a huge issue for them. I think that the Florida election, the gubernatorial election not too long ago, turned on this issue of whether or not charter schools will be promoted and protected and grow or not. And there was a complete division between the parties on this question. So I think that the divisions will be perhaps strangely in part. On one side will be the teachers' unions, and perhaps lots of suburbanites will say, no, we want things just the way they are. And there'll be lots of minority people and urban people who will say, no, our children deserve better. The question is, what are everyone else going to do? Where are they going to be in all this issue? So it's going to be a huge political issue with a new lineup of how the sides might stack up.
Do you think there'll be efforts in states, if the court rules the way we hope that it will, do you think that there'll be efforts in states to kind of create a new kind of Blaine or create new mechanisms?
It's hard to imagine what that might be if it's the decision is as broad as Erica thinks it might be. It's hard to imagine how you could do that. If there's no possible religious discrimination, then anything that's freely available to all has to be available to a religious school. So that's hard to see how that could be. What I would think instead is going to happen is just an effort politically by those who will oppose any tax credits or vouchers of any kind going to any kind of religious school or anything outside the public schools. And on the other side will be those who say, let 1,000 schools bloom, something of that nature.
So I have a question for Erica. So in the process of working on this case, what surprised you the most about it? What's been the thing that's been the most unpredictable?
I think it was all pretty predictable. We've been waiting to get this up to the U.S. Supreme Court for 20 years, and we knew it would happen one day, and now it's happened.
Great, thanks. So there's a fellow here. Yep.
Yes, Sean Kay. I have 10 children who go to Catholic private school, so I'm really interested in vouchers. Anything you got. But oddly enough, was at a meeting yesterday of the Boston Leadership Forum where this very topic came up. And it was there that the superintendent of the Boston schools mentioned that Justice Thomas, in his experience, has gone out of his way to introduce commentary related to the Blaine Amendment for cases totally unrelated to this topic. And I'm wondering, does he have a voice, an active voice, as far as we know, that might help some of the others as they decide this particular case? Thank you.
So we definitely expect Justice Thomas to rule for us. But actually, a lot of justices over the decades, both liberal and conservative, have commented on the Blaine amendments and how they do have this legacy of anti-Catholicism. So the court is definitely going to have that in mind as they're deciding this case. They certainly do not want to be blessing discrimination, whether it happened 100 years ago or 10 weeks ago.
Could you, just to follow up on that a little bit, could you talk a little bit more about Trinity Lutheran and how they are able to get the 7-2? That's a pretty sizable majority, and on a court that often turns, 5-4. What did the historical animus against religion, did that play a factor in it? What was the
No. So that's why. So everyone loves to talk about the history in this case, but it's very possible the Supreme Court won't even comment on it. There was a Blaine Amendment at issue in Missouri in the Trinity Lutheran case, and the court did not comment on it at all. And I think it's because it makes the court uncomfortable to start talking about the motives behind legislation, because sometimes there could be more than one motive, and it happened a really long time ago. And while these Blaine amendments used to discriminate against Catholics, they're being used against all religions today. So I think the Supreme Court's going to have it in their mind. It's a very useful narrative to frame for the case, but they may not say anything about it, and they didn't say anything about it in Trinity Lutheran. What they're going to focus on is the discrimination in this case today, and whether excluding parents from a program just because they're exercising their religious preference for school, if that's a problem under the First Amendment. And under the fundamentals they laid down in Trinity Lutheran, it is a problem.
Great. Here you go.
I am a supporter of the Institute for Justice, but
Thank you.
Wasn't there a case, I think, in Oregon where a severely disabled child was able to go to a religious school? They broke the Blaine Amendment. That's what Ray Flynn has been saying. He has a grandson or a nephew that's disabled. He said once to us, "It's my tax money. I should be able to send him." But wasn't there a case that broke a Blaine Amendment about they wanted to send someone to a religious school that was a disabled under special ed?
I am not familiar with that case. My understanding was the Blaine Amendment in Oregon is still alive. But there have been a lot of cases where parents have wanted to use resources for their children who are disabled and continue using those resources once they leave public school and to go into religious school. And the courts have split on that, whether or not that's okay. And that just goes to the big controversy that's been going on for decades about what these Blaine amendments really allow the states to do and what they allow the states to deny benefits for. And that's why the U.S. Supreme Court has taken this case. This doesn't just affect school choice issues, it affects a lot of government programs. It's been simmering for a long time, and it's time for us to get resolution on this question.
A couple more here, yeah.
Thank you for your time. I am rooting for your cause, and I hope you win. I expect you will. As part of your defense, perhaps, when you frame the argument between very narrow decisions like Locke and the broader decisions, would it be useful for your case to draw a line where there's a school where you wouldn't support or would be out of the bounds of this case, right? I'm thinking about Marlboro Baptist School or something even more extreme and perhaps evil. Do you have any line, or is it anything goes after this, after your victory, which I'm sincerely rooting for?
So that is an excellent question, and it's something that our litigation team has been thinking about a lot. And because some religious schools may have doctrines that we don't like as a society, some may have discriminatory policies, and the answer that we keep coming back to is that every state has curriculum requirements or neutral criteria that they impose on every private school in the state. And they say, in order to be open and have your doors open, you have to just satisfy very basic criteria, whether that's, teach math and science or not discriminate against race or what have you. If a school is satisfying those requirements and allowed to operate, then why shouldn't they be allowed to participate in a school choice program? So that's what I think the answer is in that case. And luckily, I don't think the Westboro Baptist Church has any programs. And I hope if they did, that it would not satisfy that criteria.
Thank you. I guess this is a question for Erica. So you mentioned a couple minutes ago that you've been waiting 20 years or so for this type of case, and with the
Not me personally.
right, but just the movement, and that was one of my questions: is given the age of the Blaine amendments, why has it taken so long to get to this point?
You know, I've never thought about that before. So I think for a lot of the Blaine amendments, there's a lot of the states have interpreted their Blaine amendments in ways that are actually fine. They've interpreted them to be coextensive with the Establishment Clause. So they're not actually doing any work. It's only 14 states that have interpreted them in a very problematic way. And a lot of people don't have the resources to litigate cases. They get discriminated against and they give up, and it never gets to a lawyer. And all the cases that I've seen about Blaine amendments, there'll be like a couple from like the 70s or like the 80s, but it's really maybe in our more litigious time that this has been coming up over and over in the last 20 years or so. So maybe that's the answer to your question.
Hi, I'd like clarification about something. If the U.S. Supreme Court decision declares can the U.S. Supreme Court declare a provision in a state constitution unconstitutional?
That's an excellent question, and yes, they can, and they've done it before. But I'm aware of 2 cases where they've done that. But importantly, in this case, they actually don't need to declare the Montana Blaine Amendment unconstitutional. They can say that it was just unconstitutional in this instance, and it's called saying something's unconstitutional as applied. And that's what we're asking the court to do in this case, because Justice Roberts in particular doesn't like to go out of his way and just start striking things down. So if they can do a narrow remedy, they'll go for that. But the great thing is that if they say it's unconstitutional as applied in this instance, that is a huge victory in itself, because that will mean that none of these Blaine amendments can be used against school choice programs.
DA.
My name is D.A. Mattel. I'm a newspaper man. I know what off the record is. When the Northern things blew into Massachusetts for one term, they were going to lose, but younger voters, they turned to younger voters who overwhelmingly supported them. And my question is, are younger voters always, any of you can answer, are younger voters always smarter than older voters?
You've got 2 kids.
I think that depends on how they're raised.
What school they went to.
Absolutely.
Yeah, sure.
Yeah, I'm just curious about the strategy of politically repealing these amendments. And, you know, if you didn't get the signatures approved that first time, like, why didn't you go back and try again with more signatures without the squiggles? Or like that slide that showed all the states that appeals were attempted and failed. I mean, isn't that kind of a bad fact before the Supreme Court, where they could say, like, you know, geez, like, why don't the voters of Montana or Massachusetts or like Louisiana has a lot of Catholics and they don't have one of these amendments. So as a political thing, rather than saying that the free exercise clause prevents a state from choosing to manage its spending in this way, just why is that so outside the realm? Like, why is that such a severe infringement on someone's religious liberty. Like, you could be a good Christian and not send your child to this school. Like, so that's my question.
You want to answer?
I'll say something about that. Obviously, the Bill of Rights, including the free exercise clause of the First Amendment, was enacted to protect religious liberty regardless of a majority view. And that's exactly why the whole Bill of Rights was enacted, to protect against overweening power, either by the state or by the people, to suppress the rights of the few. So under the Bill of Rights, the rights of the few prevail over the political power of the many. And whether we lost politically in the ballot box or through lack of sufficient signatures, if we have a right, the right should be protected even though we failed politically. I will assure you that the political fight will come again, and it will come noisily and angrily and everything else that goes with our politics today. It will come as to whether or not states will enact vouchers or tax credits.
So just to follow up on that, and Mike knows a lot more about it than I do, but as he mentioned, in fact, I really got first interested or learned about this topic back in the late 80s and early 90s when William Bulger, who was the Senate President of Massachusetts, very prominent Irish Catholic politician, he and I think it was Bill Weld, who was the governor, sort of liberal Republican, Brahmin, got together, and there were, I think, a couple efforts at constitutional conventions to solve it at the state level with a supermajority of the House and Senate, and they lost narrowly. And my recollection is Bulger went after it a couple times, but they did try to. What I'm trying to say is that they did try to address it at the state level, and they did try to go the political route. I think before they tried to put it on the ballot, which would have been complicated because that second anti-aid amendment in 1917 really prevents you from going that route. But they lost narrowly. It was my recollection of that, and it was hard fought. And if there was anybody who could kind of gavel things through and make it happen, it would have been Bill Bulger. But but you remember that at the time, right? I mean, do I have the chronology right or no?
You've got the idea. That's how it went.
Yeah. So.
I'm worried. I'm religious myself. I'm Seventh-day Adventist. I would love kids to be able to profit from that. But there is a matter of context. So, first in Louisiana, I don't know if they have a program for kids to get scholarship. So they do, okay. Now, as you said, it's gonna be, if it's a victory, it's gonna be a big victory. And with a big victory comes big opposition, because this is the scenario that I'm thinking of. Then you have these programs, and then a lot of people start using them, and then suddenly you have state supporting a lot of religious schools, and there has been a tolley before against that. It's your right. You have an argument. It's clear. People have the right to choose their schools, but then in practice, that's what it looks like, because you have a lot of people using it, and then suddenly there's a tolley. What's going on here? The state is sponsoring a bunch of religious schools through the right of students to choose their schools. And I understand it's a conservative Supreme Court. You might have, it might be lean toward your way, but traditionally there has been a lot of resistance to these kind of things. And then lastly, I'm wondering if once that happens, a lot of states don't go about canceling those kinds of programs.
So wonder if I can answer just quickly on it. So one of the ways I think to help think about this topic is that in the two systems of education that we have in this country, we've got the K-12 system, which has largely been, through these Blaine amendments mostly, but through other difficulties, really struggled, right? I mean, that's a generous way of saying it. We've been in a lot of stagnation and decline for decades, but it's really struggled. Then the other system of education we have in this country, which is not really a formal system at all, it's the higher education system, which is the envy of the world. The reality is it's totally decentralized. It's totally choice-driven. No one for 1 minute would think about discriminating against any student from getting a state or federal loan that would allow them to go to Holy Cross or Brandeis or whatever religiously affiliated or whatever kind of college or university they would want. And I think there's a lot of, it's instructive. We should be looking at the model that's the envy of the world and saying, hey, we need to be kind of doing more of that and figuring out, hey, the K-12 system, which is stuck in the stagnation and decline, and that people across the political spectrum have been wringing their hands to try to solve, try to learn what it is that we know works. So that, I guess that would be my kind of quick comment, but either.
No, I absolutely agree with you. And there's something else that I think you should consider. Right now, most private schools are religious, right? It's about 85%, and that makes people uncomfortable, especially people who are not religious. But if every state had a school choice program, and if these were big programs like you're suggesting might happen, I think there would be a bigger demand for secular and non-religious schools, and more of those schools would rise up. In fact, one of the great things about school choice programs is it encourages educational innovation. And if parents have this check that they can bring to the school that's best for their kid, schools will pop up and start experimenting with different educational philosophies, whether it's religious or non-religious. And right now, that's a luxury that only the rich have, and everyone should have that. Everyone should be able to figure out what's best for my kid.
Yeah. I would just sort of punctuate that by saying, when the political elites in our country, irrespective of political party, when they have the opportunity or the means to send their kids to school, they send them to Sidwell Friends, or they send them to Exeter or Andover or Deerfield or what have you. The reality is a lot of those schools, particularly in the Northeast and particularly in New England, a lot of those schools start off as religiously affiliated schools, and a lot of those schools early on actually did get public money to help subsidize them. So it's not out of the narrative or the custom or the tradition in this country. It's just not one that we think of more immediately. And I think that when you look at the founding documents and you look at the founders and their view of education and how vital it was and is to as serving as a wellspring for our republic, they understood that it's going to look different for different people, and according to what Jefferson called the dictates of their conscience. And I think they seemed to be pretty happy with that. They liked factions, they liked disagreement, they liked institutions that were dynamic and could change over time and had the legal sanction to be able to do that. So one final question in the back.
So this is a question for Erica. You had said that the case was, for the most part, predictable. And I was curious if you had predicted that the Montana would shut down the entire scholarship program. That's my first question.
That I did not predict.
Okay. Number two, did that change your strategy in litigating this? And three, what do you think their rationale was to shut down the program? Was it an admission that they were wrong, that this was not tenable, their position? That's my question.
The reason I think, and a lot of people think, the Montana Supreme Court shut down the whole program is because they did not want it to go to the Supreme Court. They were trying to make this what's called a bad vehicle. The Supreme Court likes to take cases that are very clean procedurally, like kind of simple facts, and they wanted to throw a wrench in that by throwing the whole program out and hope to evade review. And they failed at doing that. The way it changed our strategy is immediately after that happened, we asked the Montana Supreme Court for what's called a stay to allow even though they had this decision, to allow the scholarships to go forward for this school year. And because otherwise you would have all these parents that would be left out, without these scholarships they were counting on. And the court did grant that stay, luckily. So everyone right now who is supposed to get a scholarship is getting a scholarship. And that's just for this year only, but once we win, they'll be able to apply once again.
Great. Well, this has been really wonderful, and again, we're really grateful to Institute for Justice, Paul Peterson, and the folks at PEPG for all your good work on and co-sponsoring this, and hope you folks have a good evening.